What's going on, everybody? It's your boy Savage Truth. Today I wanted to talk about abortion and how abortion became a constitutional right, but only because of a trick of semantics. Now, let me share a brief history with you guys about abortion rights and the tricky language behind law. Now, in 1963, the U.S. Supreme Court made a landmark decision, which later became known as Roe versus Wade. In this decision, the court ruled that the Due Process Clause of the 14th Amendment of the U.S. Constitution provides a fundamental right to privacy that protects a pregnant woman's liberty to choose whether or not she wants to have the child or have an abortion. But in reality, there is no such right under the 14th Amendment. And although the Due Process Clause is part of that amendment, the amendment has been reinterpreted and taken way out of context. Now, let me explain how this is possible. When dealing with law, there exist two forms of interpreting it. The first being textualism, which interprets the meaning of the legal text without considering the intention with which that law was created or is legislative history. And intentionalism, or original intent, which references the history of that law in order to understand the intention with which that law was created and how it should be applied. So then if we look at the 14th Amendment using intentionalism or original intent rather than textualism, then we'll all draw the logical conclusion that the 14th Amendment has absolutely no language that supports abortion or the right to terminate a pregnancy. Now, for those of you unfamiliar with the history of the 14th Amendment, here's a short history to help you understand why it has absolutely nothing to do with abortion. Now, immediately after the Civil War, which lasted 4 years, people of African descent became freed men and women. And because of the fact many became targets of white supremacist groups, Congress adopted the 14th Amendment on July 9th, 1868, 3 years after the Civil War. The amendment's first section included certain guarantees written in the form of clause or articles of extended law. Equal protection clause, privilege and immunity clause, even though today white privilege is still a real thing in many states. Equal protection clause, and conclusively due process law, which feminists claim protect their rights to privacy as autonomous entities. So you see, it's all about semantics and wordplay. Roe versus Wade could easily be classified as judicial activism with no definitive law it can reference to legalize infanticide. So instead, they reinterpret law in a conceptual manner, practicing textualism, give humans titles such as autonomous, meaning having the freedom to govern yourself, while paradoxically expecting the government they're claiming autonomy from to fund their agenda using tax dollars from people they're telling to stay out of their bodies and their ovaries and their business. Conclusively, Normalia Nelson McCorvey, better known as Jane Roe, the plaintiff in Roe versus Wade, lied about being raped to gain empathy and remorse and popularize and get support for the law and to get it passed on a national level. And even though the damage was already done, she immediately regretted her lie, and Roe versus Wade left her lesbian lifestyle behind and converted to Catholicism and championed for pro-life till her death in 2017. But ultimately, there's one fact that still remains true even today. How feminists use laws adopted to ensure certain freedoms for people of African descent that were already being guaranteed to Europeans and turned it into a law, or should I say choice, to abort more black babies than are being born in states like New York. Stay informed.